I can make a further record of some of the comments, but Mr. Johnson is apparently under the impression that because he had and still has.
All right, folks, before this hearing even kicks into gear, we've got a public defender asking to approach the bench, a move that usually means there's some behind-the-scenes drama or sensitive information. Think of it like calling a timeout right before the game starts. Let's see what's brewing.
Consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but I'm
sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. So he, Mr. Johnson is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of this location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but subtle since he's...
Looks like Mr. Johnston decided that no contact doesn't apply if you borrow someone else's phone. Spoiler alert, it does. When the judge tells you not to call the victim, that includes burner calls, third parties, and your cousin's PIN number.
Been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, I'll just leave it at that. I'm asking the court right now.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I'm going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have two different cases. Obviously, she's not listed as a victim. In this case, it's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I would request the actual calls from this.
Did you catch that? The judge just dropped some sarcasm so dry it could crack pavement. Affectionate with all the F's? Translation. The defendant may have used some spicy language about the court. Let's just say judge is not amused.
State instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
What's the kinda?
I've never been in like court like this before, so I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of effect of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
no contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform. Is that clear enough for you?
Yes, Your Honor.
And understand something. I don't believe in coincidence. So if there's contact, I'm going to believe that you purposely did it, either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know, because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's PIN to try to...
Here it comes. Mr. Johnson tries the old, I'm new to this defense. Listen, watching court TV doesn't earn you extra credit in real court. When a judge gives you a direct order, pretending not to understand, won't save you from the consequences.
Make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you?
Yes, sir.
Do you have any other questions regarding what I mean by no contact?
Oh, Your Honor.
I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim, because you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1-week adjournment, or is that not enough time?
If you want, if that'll work for you. If you're trying to get I don't know about the discovery. That's the other thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
The 911 call problem.
June 12th,
Thank you.
2025, 9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Court calls the case, People versus DeAndre Cersei.
Hey, Richard. Oh, I'm sorry. I'm so sorry.
Evan, our attorney requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rachel McDuffie, Your Honor.
He was here on Tuesday.
Yes, Your Honor.
And when he was trying to make the actual prosecutor run out to find somebody, and he was doing absolutely nothing. He didn't even step up to say, can I help? And can I go out? He just did nothing. He just sat there. You remember? You do? And then I said, you go. And then he went. And you know what? He didn't even come back with the person. I don't know what he was doing out there. He just kind of sauntered back in. I don't know. But nevertheless, permission to practice is granted.
Evan, our attorney for the people, Your Honor.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Cersei.
You state your name.
DeAndre Cersei.
Thank you, sir. You're looking for an adjournment
Yes, Your Honor, we're looking for an adjournment to continue negotiations with the people.
for the 17th or 26th.
June 26th would be fine, Your Honor.
I knew you'd take that. And the only reason I gave Bukovich a choice because last Thursday, I don't really feel sorry for people, really. I feel sorry for you. I really did. I mean, he was so confused. He was giving it, pointed toward the door. Just turned his back on us. It's okay. I'm a forgiving person.
Thank you, Your Honor.
You don't mean that. Probable cause June 26, 2025, 9 a.m. Bond will continue. Thank you, Mr. Cersei.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Chad Jones.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Jones, who's approaching. Mr. Jones, can you say your name for the court?
Chad Jones.
Your Honor, there is a pattern with me this morning. I'm asking for Mr. Jones to be released to treatment. I do have a proposed order. I did discuss this with Ms. Douglas, and I don't believe she has an objection. Sorry. The issue, may I hand an order, proposed order to Ms. Douglas?
Can you? I don't know. Yeah, go ahead.
Mr. Jones does have several holds, including 2 holds that are bond denied. However, I have been in touch with his attorney in his Wayne County case, where he's going to try to get him released to treatment with a tether in the Wayne County case. And obviously, he's not going to be released from here until he deals with those 2 holds anyways. But we are trying to get the ball rolling. And I just am realizing, and I apologize, Your Honor, I did not put a tether in this order. And that is one thing that Ms. Douglas and I discussed. So I apologize. I can revise it.
And that was going to be on a GPS tether.
I don't have objection to release to treatment. If there's a tether, I do think that would be Mr. Jones.
I'll just insert it after available. I'll insert with GPS prior to release.
Thank you, Your Honor.
All right.
And I should have given this. I'm sorry. I am asking for an adjournment of the PCC for continued discussion about resolution, global resolution, as Mr. Jones has multiple cases.
Yes, he does. June 17th, 2025, 9 a.m. Bond will continue. I signed the order.
Thank you, Your Honor.